5:30.
Just to remind members to keep their phones on silent. Possible. Agenda item 1 is apologies. Raymond has sent in an apology. Anyone else? Nope. Okay. Agenda item 2 then, draft minutes from the 3rd of March, pages 6 to 11 of the meeting folder. So if members are happy enough to glance over the minutes and indicate if they're happy enough. Great. Everyone content with me to sign the minutes? Thank you. Cool. Matters arising. The only one issue was, members might be aware, yesterday in the Irish News there was an article around domestic violence courts being rolled out across Northern Ireland. I had contacted Tim, who very helpfully got back to me with a response. Effectively, as I suspected, it's a little bit misleading, the article. We're not actually talking about domestic violence courts, more about listings, as is the case in Londonderry, and we're not quite there yet. But there's a response there from the department that I can circulate to people if they're interested in that. But I appreciate Tim getting back to me before today's meeting as well, just to clarify that. Agenda item 4, reducing avoidable delay in the criminal justice system. Members will be aware that officials from the department, PSNI and Public Prosecution Service, are attending this afternoon to provide an update on the programme of work to reduce avoidable delay in the criminal justice system and the current performance in the Crown Court, Adult Magistrates Court and Youth Courts. Members will find the relevant papers at pages 14 to 92 of the folder, so the officials want to come on forward to the table. I'll welcome Karen Pearson, Deputy Director of Criminal Justice Division, Chief Superintendent Stephen Corrigan and Kieran McQuillan from the PPS as well. So you're all very welcome. Karen, I think you're taking off, is that right? And then we'll open up the questions afterwards, so whenever you're ready.
I'm going to be very brief, Chair. We've given you a paper and some statistics. When we were here on the 8th of October, you asked that we return with an oral update on performance before the end of the mandate. Very pleased that Stevie and Kieran could be with us today as well to provide you with further insight into measures within their respective organisations and how these are monitored. We obviously know operational independence of PSNI and PPS within the department, but an appreciation of each other's business objectives has facilitated the joint delivery of projects aimed at speeding up the justice system. In our paper, we noted a focus on legislation, performance and innovation. Non-legislation committee is obviously very familiar with the speeding up justice measures that we jointly took through in the Justice Act 2015. On performance issues, Stevie and Kieran might touch on a project called Working Together, which is led by PSNI and PPS, if that's helpful. And in terms of innovation, the recent pilot in ARDS has demonstrated that cases in the Crown Court can progress more quickly as a result of very close engagement and positive working relationships. And that pilot is now the subject of an evaluation. Moving on to talk about the detail of performance, you'll note the standards in the performance report that we've tabled for today were developed just after devolution, and we think we're at the stage where we need to set new and more challenging targets for the next mandate. And as the current reporting system requires significant interpretation, we want to produce, as I said in October, more informative and user-friendly visual reports that show how the system is performing. And if you have any thoughts on that, we'll obviously take those on board. Thank you.
Everyone else happy enough just to pick up where I ask questions? Just in terms of the main stumbling blocks that there are to reducing the time it takes for cases to be completed, what are those stumbling blocks? And has there been any sort of change in terms of trying to address that over the last number of years?
I think, certainly from the department's perspective, we've had a focus on, I think, legislation, a performance culture and innovation such as ARDS. And I think we've had to look at really every aspect of the system. So you'll be familiar in the Justice Act 2015, we've got reform of committal, we've got statutory case management coming along. We think we need to look at every aspect of it, really.
I think performance in the Crown Court is quite a bit off the target was set. Average days, excluding recess time, 517 against a target of 378. Why is it so far off the target?
In the Crown Court?
Yeah.
I mean, I think it's fair to say that we have had a period of time that these figures cover where there has been a dispute, which some of the cases haven't been able to resolve. But leaving that to one side, we would accept that performance in the Crown Court is not as good as in the Magistrates Court or Youth Court. These are obviously more complex cases. There's a whole number of challenges around those. And we think that some of the innovations that Karen has spoken about around committal reform will go some way to dealing with the performance in the Crown Court. The lessons that were learned from the ARDS pilot, which are being applied to the more serious cases, murder and manslaughter cases, again, may be something that can help assist with that, as would statutory case management. But they're complex cases in the Crown Court. They go through a number of stages. Each one of those stages can attract delay, and avoidable delay, and that's what we hope to deal with.
And obviously you said about disputes and things like that causing a little bit of an issue with the figures. Given that we're just coming out of a period where there's been another strike or barristers off record, are we expecting the figures to get worse then in the next 12 months?
I mean, obviously there's been a lot of cases that haven't been resolved because of the dispute, and hopefully now they can be, and I think steps have been taken to try and resolve them quickly. It's probably too early to say what the impact will be on the figures, but it certainly won't be a positive impact.
And in terms of, I understand that the Crown Court cases tend to be a little bit more complex. Is there any pattern of where that hold-up nevertheless is happening? Is it, I recognise you're all at the table today, so it's more difficult for you to blame each other, I suppose, if you're here separately. Is there any sort of pattern of, I mean, is the delay on the police side of things, preparing files, the PPS, is delay there? Where is the pattern suggesting that the delay has been?
I think maybe if we touch on the Working Together project and see the sorts of issues that are being addressed by police and PPS, that was in response to a Sagini inspection report.
Yeah, the Working Together project was set up following the Sagini report into the quality of police files. It was one of the key recommendations. It is a very different approach and a new approach taken. The police and the Public Prosecution Service are working dedicated full-time resources to this project. It's time limited to December of this year. It's got a whole range of objectives to try and deal with the sort of issues that probably feed into delay in the Crown Court cases, especially the establishment of much more early engagement between police and prosecutors, pre-charge advice and prosecutorial advice at a stage with police, the establishment of proportionate file building as well. I mean, you asked about delay points in the Crown Court cases. One of the issues is that there's quite a lot of nugatory work in building up cases, because a lot of these cases end in guilty pleas, but because of the system we have, they have to be built up to a certain level. We're trying to, with Working Together, we're going to try and reduce the amount of, to do proportionate case building and reduce the amount of nugatory work. We're going to be working together on forensic strategies that allow the sort of proportionate file building or proportionate forensic reporting, which again can help deal with delays. So that's going to be a very significant development, and as I say, it's time limited to hopefully conclude in December of this year.
Okay. And in terms of the youth court, obviously there's been some improvement there. How much is that down to just a reduction in the number of cases in terms of a number of diversions away from the courts?
I think that's had a significant impact, Chair. Yes, absolutely. The youth engagement clinics have proven very useful, and the number of children going through the justice system has reduced.
Given that the success in the court is because fewer cases are actually getting to court, being diverted away, and that in the Crown Court we're still some way off target, can you say that there's been any improvement in terms of speeding up justice in the last 5 years?
Yes, I think that it's absolutely the case that there has been better system performance, but we've got a lot more to do. I think we've built the foundations for doing much better in the next mandate with the Justice 2015 Act and the measures we took through there. We want to try and get committal reform and statutory case management in before the end of this, the next financial year, and hopefully we'll see a big difference there as well.
Members, any other?
Thanks so much for the presentation. The Director of Public Prosecution Service was on this morning's interview, and he was talking about some of the been a difficult week for the PPS in a number of areas. He talked about the importance of relationships and communication, and at one stage he talked about I think that the term was used, closer engagement between the police and the PPS. Maybe Stephen, has that been improving then in your estimation?
Very much so. I mean, I've been working very closely with Kieran for the last 5 years, even on my previous role as a district commander up in G District in Londonderry. And I've certainly seen that. I mean, I chaired a partnership committee with Justice Partners. Okay. For example, I chair the Investigative Standards Committee for the PSNI, and I've recently agreed with PPS and Forensic Science that they would become part of that committee. And so we look not just at our internal standards and how quickly we're processing investigations, and it's particularly focusing on the quality of those, but we've taken the step to invite PPS colleagues and forensic scientists to be a part of that and to broaden out the conversation in terms of what are the challenges for PPS, what are the challenges for forensic science, and hopefully then to build up those partnerships and make it more speedy.
One of the other points he did make was in relation to cases that go back maybe, they talk about 10 years, 20 years, right back to 40 years. I just wonder how many of those cases would be in this bracket, because what he was saying is that the longer it goes on each year, much more difficult, because the evidence is hard to gather the evidence, and it's not the appropriate evidence for in terms of scientific approach to the whole thing. Would you have any idea what percentage of those cases would be from the past?
I wouldn't have those figures, but I mean, I think...
Because obviously that would slow things up, I would imagine, wouldn't it?
Absolutely. I mean, I didn't hear all of the director's interview, but certainly delay cases from the past, you know, they're difficult cases. There's no question about that. And the longer you have to go back, the more difficult challenges there are with those cases.
Okay. Thanks, Chair. Thanks. Thank you, Chair.
Thank you, Chair. In extending cases, the pilot cases, to more serious nature of offences, murder and manslaughter, when is that taking place, and have you targets to reduce the time in those type of cases?
The principles of the pilot are being already applied to murder manslaughter cases. It ties in with a reorganisation within the Public Prosecution Service, where one part of which is we have established a serious crime unit which is going to deal with those very serious cases, including murder manslaughter. So we have a dedicated group of prosecutors who have experience of the pilot. Some of them have experience of the pilot. There's already a very high level of early engagement with police in these types of cases. So there isn't a target as such in a certain number of days, because the hope is not just that the timeliness will be improved, but the quality and the efficiency of the process will be improved.
Yeah, because sometimes we see cases in England or Wales or Scotland, and somebody's charged with a serious offence like murder. It was a particular one a couple of years ago where a woman was murdered just during the snow. Within a year, somebody had been convicted, whereas here it could take 2 or 3 years.
I mean, the pilot had shown the potential for really speeding up cases through the system, where the appropriate cases can, you know, some of the cases that went through the pilot, for instance, a very serious case reached committal in 3 months, which is in the Crown Court in 3 months, which would be, for those who've worked in the criminal justice system, would be very surprised at how quickly it can be done. Not every case lends itself to that, but it's not just about speed. You know, it has to be working together with police, and early engagement with police improves the focus of the case building, and that's important also.
And why did that happen? Why was that so quickly brought about, Kieran?
Well, one of the things that is very important by working together with the police in the pilot has shown has been the ability to perhaps assist with things such as forensic submissions. So where a prosecutor can be involved at an early stage, they might be able to say, well, the case is going to be along this line, and therefore the number of forensic submissions that maybe previously would have been made and the time that takes to process them could be reduced. So those sorts of areas can be focused on, and as I say, there's less need to case build for parts of the case that aren't going to actually be at issue at trial.
Okay, thanks, Chair.
Danny?
Thanks, Chairman. You're very welcome. Thanks very much indeed. Just, there's a lot of data there, and which I suspect is good from your perspective, because it confuses us. By the way, not everybody used to my sense of humour. But you've sort of said that you think there is reason for optimism in the new mandate. Why? Just explain why it's going to be better in the next period than it has been in the past period.
I think in many respects, working together, closer engagement, proportionate file build, reform of committals, statutory case management, we're moving on everything possible. I also think You're absolutely right about the data. We need to present this in a way that aids the committee to keep us under scrutiny. We'd like to present this in more of a timeline form than quarters that you have to go back and compare against each other. You need to be able to see how the system's moving up and down. So I think at every level we hope that we'll see improvements next month.
The level of adjournments in each court, as it seems, or each sector of justice, seems to be abnormally high or almost unacceptably high. What are the prime reasons for adjournment in your view?
I'd have to say there's a number of reasons for adjournments, but I think one of the key things that we're trying to work towards is getting it right first time. And that's one of the benefits that's going to work from police, is that if the evidence that is served at a very early stage, preferably for a first hearing and in less serious cases, is sufficient for a defendant to be able to indicate a plea of guilt or not guilty at that stage, we can really move towards the case concluding in whatever way that is, whether that's a guilty plea or a trial and a verdict. So the things are tied together. So if we can work with the police to get a better quality of file submitted to ourselves, get a decision right first time and get that before the court, our hope is that will lead to a reduction in the adjournments. The reasons for adjournments, there has been research, very much more detailed research than you have in the papers, and there was, I think, possibly over 20 different headings for adjournment reasons, and they were spread throughout those. So there are a lot of different reasons for adjournments by different parties. The prosecution, the defence, the court as well can sometimes not be able to deal with the case. There's some built in that are automatic. There's some unavoidable adjournments, but some of them certainly could be reduced.
But in a system that is overloaded, if you like, with legal aid, there seems to be a bit of a tendency that an adjournment doesn't matter. You just continue to play the system. Everybody's being paid at the end of the day, but it's. The percentages are unacceptably high in terms of the delays. How do you react to that?
Well, I think the statutory case management that Karen has already referred to, and there's already case management in the courts, even in the time, over the last 10, 15, 20 years, where some of us have been before the courts. I think there is a much tighter case management even now than there was in the past throughout the courts. The hope is that statutory case management will eliminate those perhaps unnecessary adjournments. But I accept, there's a large number of adjournments there in cases. There's no question about that.
What does it need more of? The entire system. If there are the blockages that there clearly are, what do we need more of? Do we need more solicitors? Do we need more judges? Do we need more policemen? And I'm not going to advocate that we need more criminals, because we seem to be clogging up the system with that. But what's needed here to fix this? Or do we just need a smarter way of working?
It is partly that, and I think the arts pilot showed us the art of the possible in terms of some really important principles. Forgive me, Chair, I'm going to repeat the same list really. It's the Working Together project, arts principles, and the law reform that we've delivered. But Kieran's absolutely right. It's also about the relationships, and Stephen's mentioned that, and how we work together. But I'm not sure one single thing will fix it. We've got to have a focus on all of these things.
Where do we look for aspects of best practice or better practice? What are they doing? How do we compare with other parts of the kingdom and other jurisdictions? And what lessons can we learn from them? Presently, are they worse or better than us in their throughput?
There's different systems, particularly I'm thinking of England and Wales, where they have different systems, particularly in respect to the Crown Court and their committal systems. I was at up Parliament buildings when Sir Brian Levison was here, and I read his report, and there were some very interesting observations from him about efficiencies in the criminal justice system. Now, not everything in England and Wales can be transferred to Northern Ireland, and not everything in England and Wales works, I'm sure, as well as they would like, but I think some of the the observations he made around the transforming summary justice, for instance, in England and Wales, where they really have reduced the number of hearings in summary cases to sometimes less than 3 cases, on average less than 3 hearings in certain types of cases. Those sorts of efficiencies, those sorts of approaches to adjournments and to cases going through the system, I think there is something to be learned from them, and I think everybody would be advised to consider those lessons.
And I think we could add to that problem solving if we can actually take people out of the system by working on their issues, as the chair has advocated. Digital justice, we've got to keep an eye on that for the next mandate and see where we can invest in that. I think they could be transformative.
Certainly are. Future. Our experience, having looked at the Glasgow drug, where there was effectively a fast-track system, where if someone, needed a referral, that referral was pretty instant because other agencies were involved and were part of that process. And yes, the costs are, if you like, at the front of the system rather than behind or in the middle. But we seem to be slow here at adapting to change.
I think we've all got politicians, the operational agencies, civil service in the next mandate an opportunity, if we start with the outcomes that we want to achieve, if we have an outcome-based approach that enables departments to work much more closely together on those issues, break down some of those silos, we really could see big change, particularly around addiction, mental health, all the things you've been saying. There are opportunities in the next mandate, definitely.
Does it need further legislation? Get it, politicians would be involved in that, or is it just in terms of oversight, or through the department, or anything else that we can be doing or need to be doing in terms of smoothing the way for improvements?
I think if we have that outcome focus, and if that's part of our language and the way we think about the problems, that would be incredibly helpful to the Department of Justice, certainly. It's an obvious thing to say, but people come to us when things have gone wrong in their life in other areas. If we can get more help with some of those issues, I think that would be incredibly helpful.
Thank you. Okay.
Anybody else? No? Okay. Thank you all very much.
Yeah.
Thank you.
Thank you.
Okay, members, if we take then agenda items 5, 6 and 7 collectively, I refer to page 93 to 186 of your packs. Members will recall the meeting on the 16th of April 2015. We agreed we were content with the proposals for 3 statutory rules to reform the police discipline and unsatisfactory performance procedures. The rules will replace existing legislation governing police conduct, performance and attendance and appeals procedures. The SR will lay by the Department 23rd of February, subject to negative resolution procedure, and it's proposed that the regulations will come into operation on the 1st of June 2016. There have been no changes to the policy content since the SL1 was considered, and the examiner has advised that he will indicate in his formal report to be published on 21st of March that he has no issues to raise. So if members are content, then I'll put the questions formally. 3 questions. First of all, that the Committee for Justice considered SR 2016/41, the Police Conduct Regulations 2016, and has no objection to the rule. Are you content? Good. Secondly, that the Committee for Justice considers SR 2016/42, the Police Performance and Attendance Regulations 2016, and has no objection to the rule. Content? Good. And finally, that the Committee considered SR 2016/43, the Police Appeals Tribunals Regulations 2016, and has no objection to the rule. We agreed? Agreed. Thank you. Agenda item 8 then. Can I refer members to page 188? Just to remind you, at the meeting on the 4th of February, we agreed we were content with the proposed SR to add a range of offences to the unduly lenient sentences scheme. Those included offences concerning indecent images of children, inflicting bodily injury with or without a weapon, offences of unauthorised or harmful deposit or disposal of waste, animal cruelty offences of causing unnecessary suffering and causing or attending an animal fight, and offences of slavery, servitude and forced or compulsory labour. The SR was laid by the Department on the 25th of February. Subject to negative resolution procedure, it's proposed that the regulations will come into operation on the 1st of April. There have been no changes to the policy content since we last considered it, and the examiner has advised to indicate in his formal report on the 21st of March he has no issues to raise with regard to the technical aspects of the rule. So if members are content, we'll put the question formally that the Committee for Justice considered SR 2016/58, Criminal Justice Act 1988 review of sentencing order, and has no objection to the rule. You content? Agenda item 9 then, referring to page 197. Again, remind the Committee in the meeting on the 18th of February, we agreed we were content with the proposed SR to increase the level of bereavement damages in Northern Ireland in line with inflation as measured by the Consumer Price Index, rounded to the nearest £100. This brings it to 14,200 based on the CPI for January 2016. The SR was laid by the Department on the 29th of February, subject to the negative resolution procedure, and it's proposed that those regulations will come into operation the 1st of April. There have been no changes to the policy content since last considered. The examiner has advised he will indicate in his formal report he has no issues to raise with regard to the technical aspects of the rule. So again, members, I'll put it formally. The Committee for Justice considered SR 2016/74, the damages for bereavement, variation of some Northern Ireland Order 2016, and has no objection to the rule. And 10 then, page 204, meeting on the 18th of February, we agreed we were content with the proposed SR that will bring into operation upon commencement of Part 3 and Schedule 2 of the Modern Slavery Act, a code of practice to be followed by Northern Ireland constables and enforcement officers when exercising the power of arrest, when they have reasonable grounds to suspect that a slavery or human trafficking offence has been committed on a vessel under investigation. The SR was laid by the Department on the 29th of February, subject to the negative resolution procedure. The Department's current expectation is that the maritime powers provisions within the Modern Slavery Act are likely to be commenced in May of this year. There have been no changes to the policy content, and the examiner has advised he will indicate in his formal report that he has no issues to raise. So, if members are content, to put the question formally that the Committee for Justice considered SR 2016/81, the Modern Slavery Act 2015 order, and has no objection to the rule. Thank you. Agenda item 11 then, page 221. In the meeting on the 18th of February, we agreed we were content with the proposed SR that allowed members of the PSNI who are retiring with a protected pension age before 55 or age 55 or over to no longer be required to purchase an annuity from their AVC pension provider with effect from the 6th of April 2015, the beginning of the 15-16 tax year. The SR was laid by the Department on the 1st of March and is subject to the negative resolution procedure. The regulations come into operation on the 29th of February, but have effect from the 6th of April 2015. There have been no changes to the policy content since last considered by us. The examiner has said that there's a minor drafting issue that can be addressed at a later stage. But if members are content, we'll put the question formally that the Committee for Justice considered SR 2016/82, the police pensions, additional voluntary contributions to amendment regulations, and has no objection to the rule. Then item 12 then, page 232. At the meeting on the 30th of April 2014, the Committee agreed it was content with the proposed statute rule to provide arrangements which the seizure of vehicles and equipment will be regulated where it is suspected that the vehicle is being operated as a taxi without proper licence. The SR was laid by the Department on the 2nd of March and is subject to the negative resolution procedure. To propose the regulations will come into operation on the 31st of May 2016. There have been no changes to the policy content since it was last considered by the Committee, and the examiner has advised that he has no issues to raise. So again, I'll put the question formally that the Committee for Justice considered SR 2016/90, the Taxis Act, Northern Ireland 2008, retention and disposal of seized motor vehicles, equipment and items regulations, and has no objection to the rule. And 13 then, referring to page 247 of your meeting folders. On the 12th of November 2015, the Committee agreed it was content with the proposed SR to amend the Magistrates' Courts Rules 1984 in light of provisions introduced by Section 94 of the Justice Act, which enable the Court to make an order allowing the defence to have access to premises. The rule will provide the procedure to be followed on making an application for such an order. The SR was laid by the Department on the 2nd of March and subject to the negative resolution procedure. Proposed the rule will come into operation the 1st of April. The Department's advised there has been a small technical amendment to the rule since it was considered at SL1 stage. The statute rule will now substitute an amended Form 2, the form of summons, into the 1984 Magistrates' Court Rules in consequence of Section 93 of the 2015 Act to allow a public prosecutor to issue a summons. The examiner has advised that he will indicate in his formal report he has no issues to raise with regard to the technical aspects of the rule. So again, members, if you're content, I'll put the question formally that the Committee for Justice considered SR 2016/93, the Magistrates' Courts Amendment Rules, and there's no objection to the rule. Content? Then on 14 then, page 262. Just to remind the committee, on the 25th of February, we agreed we were content with the proposed statute rule to amend the current Magistrates Court rules framework to assist the courts in processing applications for a violent offences prevention order. The rules will provide 4 template forms to be used for the VOPO application process and will set out 4 specific rules for the courts in dealing with the VOPO. The SR was laid by the Department on the 2nd of March and subject to negative resolution procedure. It's proposed that they will come into operation the 1st of June. There have been no changes to the policy content since we last considered it, and the examiner has indicated he has no issues to raise. So again, I'll put the question formally that the Committee for Justice considered SR 2016/94, the Magistrates Court's VOPO rules, and has no objection to the rule. Content? Good. Agenda item 15. Is a draft summary of the committee consideration of the judicial appointments process in Northern Ireland. In September 2015, members agreed, as part of the committee's strategic priorities, that a short summary of the committee's consideration of the judicial appointments process, including the key points of the evidence received from Judge Marnan, the Lord Chief Justice and the Judicial Appointments Ombudsman, should be prepared to assist the incoming Justice Committee if it wishes to undertake a review of the judicial appointments policy and procedure in the next mandate. The draft summary document was provided to members electronically yesterday and is available at pages 3 through to 10 of the table pack. So are members content with the draft summary? Yeah. And in particular, the inclusion of the recommendation that a review of the judicial appointments policy and procedures should be a priority for the next Justice Committee?
Could I just say, I think this reflects, I think, very fully and correctly the deliberations of the committee. This was an issue that exercised all of us. And I think it does justice to the deliberations of the committee, and I think it's very important that the next committee has a good look at this. It's an important issue.
Okay, thank you for that. Are members also happy enough then that the summary be published on the committee webpage?
Great.
Good. Okay. Agenda item 16 then is the draft Committee for Justice Legacy Report for the 2011 through 2016 mandate. The draft Legacy Report has been provided to members electronically and in hard copy at pages 14 to 57 of your table pack. Any sort of formatting or spelling errors or anything like that will be amended at the proofing stage, and figures and brackets in the report will be finalised after today's meeting. The end of session report covering September 15 to March 16 was circulated to members yesterday and will be included at Appendix 3 of the Legacy Report. Annex A of the end of session report that provides the committee expenditure will be completed when up-to-date financial figures are available. So could I ask members, are you content with the end of session report?
Yeah, content. It's very good work. And yes. Could I just take this opportunity to say that, again, it's a substantial body of work which will inform the new committee. And I want to thank in particular the clerk and her staff for filing it, because it really is very, very helpful and a good reminder of the work that we have done and work that remains to be done by the next committee.
Absolutely, no, I concur with that. There's an awful lot of stuff in there, and I think it just shows how busy the committee's been and how valuable some of the work that the committee has done, particularly in the last year, but even before that as well.
Of course, Chair. And the photographs are very good.
That's very recent.
Will they be in colour? Or?
I didn't know who they were.
And everybody's happy enough with the Legacy Report as well. Then.
Yeah.
If we're happy enough, then we'll go through just the formal agreement of the report. First of all, can I refer members to the title page and committee powers and membership at the front of the report? Members content that that stand part of the report?
Content.
Okay, then the committee achievements and outputs, paragraphs 1 to 39. Are members content that the section on committee achievements and outputs, paragraphs 1 to 39, stand part of the report? Then the committee approach, paragraphs 40 to 52. Are members content the section on committee approach, paragraphs 40 to 52, stand part of the report? Are members content that the section on committee approach, paragraphs 53 to 65, stand part of the report? Okay, members content that appendices 1, 2 and 3 stand part of the report?
Absolutely.
And then the committee is content for the Legacy Report NIA 32811/16 to be published. Yep, good. Agenda item 17 is an update on the Desert Crete project, page 284 of your meeting folder. The department's provided a written briefing paper setting out the current position. The outline business case, which was to include a full economic appraisal of the shortlisted options and identify a preferred strategic option, was signed off by the accounting officers of the 3 services and 2 departments and approved by the Minister of Justice in November 2015. The Health Minister approved it on 2nd February 2016. The Department of Finance personnel approved it on 26th February. An executive paper, including the outline business case, was circulated, and the department has confirmed that this was considered at the executive meeting today. So I suspect that members will get more information on that during the course of the day. Agenda item 18 is the Prison Review Team Recommendations 13. Can refer to page 334 of your packs. Recommendation 13 of the Prison Review Team related to the development of a joint healthcare and criminal justice strategy. Departments provided a draft strategy and action plan for 2017 to 22 to improve the health and well-being of adults and children in contact with the criminal justice system in Northern Ireland. The strategy represents the Department of Justice and Department of Health joint response to Recommendation 13. The 2 departments intend to launch a public consultation on the draft strategy and action plan before the end of this mandate, following which they will present a summary of the responses and updated policy proposals to the next Justice and Health Committee. So if members are happy enough just to note that. Agenda 19, can refer to page 422 of your packs. Just to remind the committee, on the 22nd of October, last year, we were informed of the department's intention to undertake a consultation on a review of the code of practice for the exercise of functions by PCSPs and DPCSPs. The department's now provided the results of the consultation, a revised draft code of practice. 12 responses were received and the majority of comments were accepted and incorporated into the document. A copy of the revised code of practice with track changes for ease of reference is included in the meeting folder. So, subject to any comments from the committee, the revised code of practice will be issued by the end of March to assist PCSP operation from April. So, are members content, or are there any comments to make? Happy enough? Agenda item 20 then, page 495. The Civil Legal Services Remuneration Order 2015 was commenced in April 2015 as part of a suite of subordinate legislation required to implement civil legal services as a new legislative vehicle to fund civil cases in place of civil legal aid. The order was intended to replicate existing legislation and associated administrative practices. Prior to the commencement of the order, an uplift of 5% was payable to Children Order panel solicitors in respect of their fees in public and private law proceedings brought under the Children Order in 1995, heard in the Family Proceedings Court or the Family Care Centre. Payments intended to reflect the solicitor's additional experience and training. As a consequence of an omission from the remuneration order, the Legal Services Agency has no legislative basis to make payments of the uplift for members of the Children Order panel since the 1st of April of last year. Given that that uplift was removed in error and that the removal was contrary to the assurances to the Law Society that the remuneration order would see no change to the fees received by solicitors, it's the intention of the Department to reinstate the uplift retrospectively. There is a provision under Article 5 of the Civil Legal Services Order to issue directions in relation to remuneration payable through the order, and a direction to reinstate the uplift has been provided by the Department. So are members happy enough to note that? Okay. Then on 21 then, page 501, the Department's provided progress reports for each of the 8 action plans to deliver the community safety strategy. Briefing paper also sets out details of the investment and programme funding by the Department during 15-16 and the delivery mechanisms used, including the contribution of the policing and community safety partnerships. So really, members, that's just for noting, unless any comments from anyone. If not, agenda item 22 then is the update on the state strategy, page 570 of your packs. The Department has provided a written update on its state strategy, which covers all the Department's core directorates, executive agencies and non-departmental public bodies. The Department has outlined the current position of the 2 main projects that make up the strategy. In relation to DOJ Headquarters Accommodation Project, the preferred location for a centralised DOJ Headquarters is in Belfast City Centre. And work continues in Outline Business Case 2 with the Strategic Investment Board and the Asset Management Unit in DFP. This will demonstrate whether this is over a single site or dual site and the appropriate procurement method. In relation to the Service Delivery Accommodation Project, the DFP has commenced a civil service rationalisation project across the whole estate, which will lead to the creation of a citizen hubs. DOJ is represented in this project board, and its service delivery project could feed into the wider project rather than sit separately. As this civil service project is established, DOJ will be able to make an informed decision on which project is a more useful or more effective use of available resources. So again, members, that's really just for noting, unless anyone's any comments. Agenda item 23 then, page 577 of your packs, the Courts and Tribunal Services intending to undertake a public consultation on a proposed increase to court fees and has provided the draft consultation document. The consultation document explains why it's required to, why they believe it's required to increase fees and invites views on 3 potential options for doing so. The preferred option of the Court and Tribunal Services to uplift all existing fees and stages over a 3-year period to achieve an appropriate uplift. Subject to any views from the committee on the proposed consultation, they intend to launch it in March 2016 with a view to implementing the first stage of a fee increase in April 2017. The responses of the consultation will be shared with the next Justice Committee in the autumn. So, are members happy enough to note?
Yep.
Agenda item 24 then, page 670. The Department's intending to undertake a targeted consultation on proposals to make a provision to enumerate exceptional circumstances in cases in magistrates' courts and has provided a copy of the draft consultation document. The proposals have been developed following similar amendments which the committee has approved already to introduce exceptionality provisions to cases heard in the Crown Court, but have been tailored to meet the specific needs of the magistrates' court setting. The Department intends to brief the committee on the results of the consultation and final proposals and implement the implements before the summer recess. So happy enough to note. Agenda 25 is correspondence, 16 hours of correspondence, pages 692 through to 799, and there's 14 items, pages 60 to 194 of the table papers. If I can just draw your attention to a couple of those. Item 5, page 706, is an update from the Department on the processing of Access NI enhanced disclosures. The improved performance in relation to turnover times has been maintained. The Department has also outlined that the timetable for the extension of disclosure and borrowing services update service in Northern Ireland, which will enable individuals to apply for a portable Access NI checks that can be used for more than one role, has slipped. It is written to the Home Office to confirm a new date for implementation and a clear commitment that this will be achieved. This is just for noting, but again, I think that if anybody's on the next committee, it's worthwhile continually getting these updates because I think it has helped improve performance and something that the committee may want to keep an eye on. Item 6 at page 710 is correspondence from the Department regarding the role of the PSNI in supporting legacy requests. The Minister has written to the Chief Inspector of CGNI asking him to undertake an inspection to review the efficiency and effectiveness of the arrangements in place in the PSNI to manage and disclose information to support the coroner in undertaking legacy requests, and has provided a copy of the terms of reference. That's just really for noting. Item 14 is an invitation from the Ulster University to an event Making Sense of Youth Justice on the 15th of March at the Belfast campus, which will provide an in-depth analysis of diversionary youth conferencing and examine the extent the ideal and principles of restorative justice are being compromised. Interesting event. It fits into some of the stuff that we've done. Unfortunately, they're holding it on a Tuesday when there's quite a bit of business going through plenary, so it's unfortunate they've organised for a Tuesday. But if anybody does want to go along to that, just let the committee staff know and they'll inform the Ulster University. Item 8, page 94, in the table papers, a response from the Department providing further information and clarification on the Erne House fire incident, the previous evidence provided in the timescale for recruitment of new officers, and the number of staff in Maghaberry Prison who have been medically retired in the past year. Again, that's for noting, but it may be useful if the next committee picks up some of the work around prison reform, and I suspect that they will. Any other items that members want to make a reference to? If not, then move on to just say, obviously, this is the last scheduled meeting in the mandate. Been asked to say whoop whoop at this point from the committee staff, added into the briefing notes. So are members happy enough, given that we're not meeting again, that any the minutes from today that I'm able to sign off on behalf of the committee, and that any correspondence that comes in from this time, that the committee staff will write back and say that we're not scheduled to meet again, but will be given a copy of that. Can I also just say that I want to put on record my sincere thanks to all the committee staff. We have a very heavy workload in this committee. The staff make it much, much easier for me as chair and for the members to be well equipped at committee meetings. The events that we have run throughout the course of the year, in addition to just our committee events, have put an additional workload on our staff. I think I want to recognise just how well those events have been run, particularly our conference, which took a lot of work in W5 and was a hugely successful event, not least because we were able to stream it live as well, and it was a groundbreaking thing for any committee to do, and I'm glad that we were able to do that. So I just want to thank everybody in the committee staff for their help and support over the last year, and more than that, thank the members for their contribution. This has been a really good committee, I think. I've really enjoyed chairing it. There's some very difficult situations that we have potentially could have stumbled upon, and I think we've worked in a very collaborative and a non-political way in many respects as well. I think actually we've proven to be very successful as a committee, and I think that even looking at our legacy report shows how well we have functioned as a unit, and I think it is an example to other committees as well. I just want to particularly thank Alban for his contribution. He's retiring now from politics. This is his last committee. I want to thank Alban for his contribution, certainly as my time as chair, but wider than that, in the Assembly over Masterton for years, and wish him well in whatever he decides to do. In the future, he may well become our advisor, you never know, or take an interest in some of the seminars.
A very substantial
Department of Justice.
That is negotiable, but if the committee does continue on with the seminars, hopefully you'll still take an interest in some of the work that we're doing. And obviously Bronwyn's not running for election again, she's not here, but we'll pass on her our best regards to her as well. Thanks. I think everybody else intends to be here in the next mandate, so I'd wish everybody well. Some more luck than others, obviously. Wish everybody well in their endeavours as well.
Chair, can I just thank you for your very kind remarks, but also want to put on record, as I did on the floor of the Assembly the other day, I do think this has been an excellent committee. It's been an exemplar, and I think that was recognised by the President of the Supreme Court in his visit. I don't think it was mere flattery or flânery. I think he genuinely was impressed by the work that we have done as a committee. I do accept what you've said, that this committee has worked very well together. It's been, in the main, not all together, but in the main, it's been non-partisan, and I think that that's been very useful. Whilst it's, there's some very difficult issues have come across this committee. We will not agree politically, nor did we agree politically on everything, but it's been conducted in a very, very good fashion and very constructive fashion. So I want to pay tribute to your leadership, but also to your predecessors as well, Lord Morrow and Paul Given. And also want to pay tribute to Raymond McCarthy. I'm sorry he's not here today, but Raymond made a very constructive contribution to the work of this committee, and he's to be thanked for that. This is my last committee, not just Justice Committee, but last committee, so I want to thank you all. I've derived great satisfaction out of being in this Assembly. It's been an honour to represent the people of North Belfast, and I'm very happy to retire, but also I'm very sad in many ways to leave this Assembly. So thank you very much indeed.
Here. Yeah. And there is cake here to mark that. And it is very good. Okay, members, well, look, thank you all very much. Thank you, Chair. And that's it then.